Now we're in the good afternoon, so thank you for allowing us to appear before you today regarding our group's opposition to SB13. As mentioned, my name is Jason Johns. Many of you know me from my time around the Capitol lobbying efforts on behalf of my clients, but also as my time as the immediate past Deputy Secretary of Wisconsin Department of Veterans Affairs under Governor Walker. I'm also a proud veteran of the war in Iraq and appeared before you today with a couple different hats on. I serve as the Vice Chair of the Legion Legislative Committee in the state of the American Legion, the Legislative Officer for the Military Order of the Purple Heart, and the Co-Chair of the VFW Department of Wisconsin Legislative Committee. I have two prepared statements that I will read on behalf of the American Legion and the Military Order of the Purple Heart. I also have with me Renee Simpson, a veteran of our military action in Bosnia, and the Senior Vice Commander of the VFW Department of Wisconsin. This June, Ms. Simpson will become the first ever woman commander of the VFW of Wisconsin, and I'm proud to have her by my side. She'll be providing testimony on behalf of the members of the VFW, but also a personal account of her father's fight with mesothelioma. When we've concluded, we'll be happy to answer any questions the committee may have. So with that said, I wish to read two submitted written testimonies that you should have in front of you on behalf of the commanders of the MOPH as well as the American Legion. For the Military of the Purple Heart, Senate Committee on Judiciary and Labor, the Military of the Purple Heart Department of Wisconsin wishes to inform this committee and your colleagues in the legislature of opposition to SB13 and its companion bill AB19 relating to torts and personal injury trust. With all due respect to the authors of the legislation, we believe there may be have some unintended consequences of this legislation upon our members and the veterans community in general. I wish to identify at this time our specific concerns with the legislation as written. Regarding the requirement of the plaintiff to disclose within 30 days after he or she files action their intention to file a claim against a personal injury trust, and if so, a stay is invoked on their proceedings in the state court. Our veterans who suffer from mesothelioma, if they're lucky enough to determine a specific defendant who may be liable, should not have their cause of action upon said defendant in state court delayed while they do or do not pursue a final executed proof of claim against such personal injury trust. This places a great burden upon the veteran to identify all possible defendants before being able to take action against one. This may well result in their claim not being adjudicated in a timely manner or prior to the defendant's death or incapacity to participate on their own behalf. Regarding the ability for a defendant to raise the claim to the court that it wasn't me, it was someone else who was part of a personal injury trust, and this claim, if made in good faith by the defendant, which is a very low threshold, requires the court to stay the proceedings until the plaintiff produces a final executed proof of claim against the personal injury trust that the defendant, not the court, identifies. One must ask themselves what defendant would not espouse this claim to buy themselves more time and possibly delay the veteran's claim to the point of being unable to adjudicate it. Regarding the requirement that the plaintiff must provide all parties to his or her immediate suit with all documents, records, trial or discovery materials, and, quote, other information relevant to any claim against a personal injury trust, this requirement appears to place a very onerous and burdensome requirement upon the plaintiff to proactively produce documents that are already available to defendants via current discovery procedures and statutes under Wisconsin law, and thus are completely unnecessary. In essence, this language would take the time and effort involved by a defendant's attorney to perform due diligence on behalf of their client and place this additional time and effort upon the plaintiff, thus again resulting in a delay that would prevent their day in court as well as the extra fees and costs involved. Finally, in regards to the requirement that if the immediate action proceeds to trial before the plaintiff's claim against a personal injury trust is resolved, the court must establish an attributed value to the plaintiff's claim against the personal injury trust and to afford the defendant a set-off in that amount. Forgive us, but unless the judge has a crystal ball or the Federal Supremacy Clause of the U.S. Constitution has been repealed, we are unaware of how this is fair, reasonable, and legal. I wish to end my statement with addressing the concerns of double dipping that has been raised by the proponents of this bill in regards to a plaintiff receiving damages from a personal injury trust, and then somehow being able to receive damages for the same cause of action from a different defendant in state court. From our understanding of how a legal case works, we believe the courts of personal injury trusts already provide a mechanism for defendants to ascertain if a plaintiff has already made a claim at the federal level, and whether or not a few bad apples have been successful in doing so. To imply that our men and women who have shown great honor in uniform would attempt to do so is concerning. And if a few have, there are fraud statutes in place to address them, the same as any plaintiff who makes any fraudulent claim in a court of law. notwithstanding the implication that all plaintiffs, whether veterans or not, have been doing so on such a scale that this is a, quote, problem that has to be remedied by this legislation, is not supported by any facts that we have been made aware of. For all these reasons, on behalf of the military of the Purple Heart Department of Wisconsin, I respectfully urge you to oppose SB13 and remove it from the tort reform package as being currently passed through the legislature. Thank you, Eric Nikinen, Commander, Military of the Purple Heart Department of Wisconsin. That concludes the MOPH testimony. Regards to the American Legion, Department of Wisconsin. The American Legion, Department of Wisconsin has legitimate concerns with SB13 and the accompanying companion bill, AB19. Many Wisconsin veterans were exposed to asbestos during the military service. Of those who suffer the effects of mesothelioma, 30% are veterans. Although we believe the intentions of these two pieces of legislation were not to target veterans' personal injury claims for mesothelioma, we believe that the effect it would have upon such claims would be unnecessary delay for their rights in state courts. As an additional consequence of this legislation, additional burdens of proof and discovery will be placed on veterans suffering the effects of mesothelioma and their family members. Our primary concern is that the potential consequences for veterans and their families are severe and unnecessary. In particular, delay for one of our comrades suffering from the fatal effects of mesothelioma would be unacceptable to our membership. Justice delayed is justice denied. Consequently, we respectfully urge this committee and legislative leadership to give due consideration to the unintended consequences of SB13 and AB19. Please table consideration of this matter in order that we may further review the unintended consequences of these bills and participate in the development of appropriate legislation. That concludes the reading of the written testimony by the American Legion Department of Wisconsin and Military Department of Purple Heart Department of Wisconsin. At this time, I'd like to ask Renee Simpson to provide her testimony.
Thank you, Jason. Good afternoon. My name is Renee Simpson. I am the Senior Vice Commander of the Veterans of Foreign Wars Department of Wisconsin, and I am a veteran of the military action in Bosnia in 1997. In addition to appearing before you today to express opposition to SB13 on behalf of the Veterans of Foreign Wars Department of Wisconsin, I also wish to share with you my own personal story of the effects of mesothelioma, and I will try to compose myself. On September 21st, 2012, at the age of 69, my father, Dennis, a fellow veteran and Army soldier, involved in the invasion of the Dominican Republic in 1964, was diagnosed with mesothelioma. As you can imagine, this was a huge shock to my family and me. I followed in my dad's footsteps to serve my country, and now the thoughts of losing him so quickly has motivated me to be here before you today. My father was exposed to asbestos during his time in the military, during barracks insulation, as well as extended time spent aboard naval ships for transport. In addition, after his service, he was employed at 3 different foundries from 1965 to 1975. In February of this year, my father began civil action against the possible contributors to his asbestos exposure. He filed a claim with the Personal Injury Trust at the federal level and is currently pursuing that claim. 2 of the 3 foundries he worked for are no longer solvent, but one is. If SB13 were to pass, his ability and my family's ability to pursue any claims against the solvent company in Wisconsin state courts would be severely affected given the multiple additional requirements imposed upon him and my families to do so. In September, after his diagnosis, the doctor told my family that my dad could have 3 months or 3 years. There is no way to determine, and there is certainly no cure. He was unable to appear before you today due to his weak health and was unable to travel. But if he were here, he would want to tell you that any additional legal procedures required that would result in a delay of any effectual prohibition of his receiving financial damages in order to take care of his medical bills now and his family after he is gone would be unconscionable. Currently, my mother, assisting my father, draws up daily 3,000 cc's of fluid off of my father's lung every day. Since being diagnosed in the past 6 months, my father has gone from a very robust man to a skeleton of his former self. Unfortunately, the side effects of having any kind of treatment would make him even more sick, to only possibly extend his life by mere months, with no cure. It took him 6 months after his diagnosis to finally realize that this is really happening, and he's no longer in denial. He started to claim to take care of my mother, who unfortunately will have to live a long time without her husband of 46 years. I too was exposed to asbestos rat piping at barracks during my time in the military. Between that and my dad's coming home with asbestos dust on his clothes when I was a child, my entire family of 3 other brothers and sisters have been informed we could very well suffer the same fate of mesothelioma as my father. If that time comes, I too could not imagine trying to contend with the additional burdensome requirements upon my own claim that this bill would impose. To think today I could be suffering from mesothelioma because of my age of 37, and the spouse of a veteran who himself has terminal cancer connected to his military service with 5 small children, what do we do? In conclusion, I ask you as a veteran, a family member of a veteran who suffers from mesothelioma, and as a potential victim of mesothelioma myself, to please oppose SB13 as unnecessary and prevent adding additional hurdles to what is already an excruciating and time-intensive process by mesothelioma victims to get their day in court and access to justice. Thank you.
Thank you very much for coming over. Any questions? Thank you very much.
Thank you.
Brett Large? Brett still here? Okay.